One of the trends that you envisaged was the one that now in interaction with Rospatent and in general with the authorities, digital communication will be the rule. We have witnessed in these days a strong change in our, let's say, approach to our profession, being it the legal profession or the business one, whereas everything has become digital. So we have digital hearings with the court, we have online and digital conferences with clients and counterparties. So everything is becoming like this. And this, let's say, brings us to the next topic, which is probably one of the most popular and widespread, and everyone is talking about it. So that is the smart working. So let's say, last years, only few people were in smart working. It was looked like a strange animal where anyone only in some areas of the profession it was the rule, but generally speaking, it was very neglected. And nowadays it has become, let's say, one of the focus of our activities, working activities in all business activities, even in the legal field. So, Igor, would you like to take the floor and explain us what are the novelties in the area of remote working in Russia, and how these will affect also, I would like also to have your comments, how it will affect, let's say, the working relationship between workers and employers. Please.
Yes, thank you, Armando, for introduction. So, as you correctly mentioned previously, the remote employment was not very popular, and now it is really a very important topic. And in our presentation, we will discuss the main issues about this. So just 1 second, I will start the presentation, the slides. So, this spring, when all this situation with COVID-19 starts in Russia, we faced with the situation when in legislation appears the new term called remote work. Because in Russian legislation so far we had only a term distant work. Just to differentiate these two words, I will name these words in Russian language to be more clear, just to understand the difference, because in English it seems the same. And distant work in Russian language is дистанционная работа, while remote work is удаленная работа. So even though the terminology is quite the same, but nevertheless in the Russian legislation there was a difference, because distant work was regulated in the Russian legislation already in 2013. There were changes in Russian labor code when distant work appears in Russian legislation. Distant work is considered normally as permanent employment, and it requires some difficulties with electronic signatures and some other issues. While remote work, the term which appears in the different regulations of Russian authorities in March, April, and further periods, and remote work was, let's say, interpreted in practice in the absence of any legal regulation so far as a temporary employment, which was a kind of a benefit for employees. And such remote work allows to combine two regimes when the employee can be in office and can be also at home. So a kind of a schedule when, for instance, 3 days employees work at home, 2 days a week in office. And the possibility of exchanging documents as scanned copies also was associated with such kind of remote work. Nevertheless, nobody knows how it should be regulated according to the law in the absence of regulations. And in practice, this remote work regime was introduced in a different way. In some cases, there was an additional agreement to the employment contract where it was stated that the employee is working remotely. In some cases, there was just an order of the employer. And with this order, employees just were familiarized, and that's it. However, such kind of uncertainty was not possible any longer, and the draft of the law on distant remote employment was discussed for a quite a long period of time, and finally it was adopted. It was signed by Russian president on 8th of December, and from 1st of January 2021, it will come into force. What is important for this law is that the law introduces different types of remote work. First of all, in the law, there is let's say a concept that distant and remote employment is the same. So, and further, we will consider this regime as just remote work, which means that it's the same as distant. And there are basically three types of remote work under the Russian legislation, which is permanent on a temporary basis, and temporary for the period of emergency or decision of the authority. And also, there is a possibility provided by the law to combine office and remote employment on the basis of some schedule. And such combination of work is meant by the law as periodic remote work. Also important is that the concept of so-called temporary remote work appeared in Russian legislation. It is the work for the period of pandemic, for instance, which we have currently, or for the period determined by the Russian authorities due to some exceptional circumstances that could endanger the life of people or whatever reasons. And this simplified, the temporary remote work allows to be introduced, so it could be introduced in a simplified manner, which means that to introduce such kind of remote work, we don't need to receive any consent of employee. And there should be no change of the employment contract, and such kind of remote work can be easily provided in the internal labor documentations. Just as a difference for the permanent and for the work on temporary basis, including periodic, it is only possible to introduce this work by written agreement with the employees. So we need to either to conclude a new contract employment or just to sign an addendum to the existing employment contract. But for temporary remote work, we don't need to do this. We can just provide this in the internal documentations. It can be an order of the employer, and this regime will be introduced. It could be introduced only for the period of exceptional circumstances or for the period determined by the decision of state authorities. It is also important that in some cases, what existed in practice in this year, that in some cases for specific employees, it was impossible to introduce remote work due to some specific nature of work. For instance, technical specialists could not work remotely. In some cases, it was impossible for employer to provide employee with the required equipment, with the required facilities to ensure the remote work. And Russian legislation provides that in such cases, when there is an impossibility for remote work, a downtime period can be established, which means that within this period, the employee will receive 2/3 from his salary, and in fact, he will not be working because it's not possible. So it's a kind of a guarantee for the employees that at least part of the salary will be paid. And this is explicitly stated in the Russian legislation. At the same time, in practice, for sure, there could be occur such cases that employee refuses to work without any reasons, or there will not be any agreement about working conditions. And apparently, we will, of course, wait for some interpretation from the courts, but most probably in this case, nothing would be paid to the employee, and probably a kind of ground for termination can be used in this case. But this is quite so far a gray area because nothing is clear. And I think that there will be some clarifications from state authorities, also some court practice that will regulate these matters. So far, it's just concept of of payment for downtime period, but nothing else is regulated. It is important to consider that some of the issues that previously were not stated clearly in the law are now regulated. For instance, business trips. Previously, it was uncertain whether business trips can be applied to remote employees. However, now in the Russian legislation, it is stated that business trips are possible even for remote employees, and it is needed to regulate this issue in the documentation to provide specific payments and all these issues. And another problematic issue that was in practice is the fact that sometimes employees are being contacted by the employers beyond the working time regime. And it was not clear whether it could be interpreted as overtime work and how it should be paid. So in the final version of the law, there are no clarifications about it, explicit clarifications. And due to this fact, it is recommended to regulate this issue in individual employment contracts or in some internal labor documentation, just to avoid any unregulated issues in practice. Another important issue is that sometimes employees are working in different regions of Russia, and due to different time regime, there could be some time zone differences between the time, let's say, for the employer and for the employee. And sometimes they could be quite significant, and it could be problematic when employees perform their tasks according to their working time, and employer in its turn is expecting to receive a reply according to his working time regime, so due to different time zone. So it's really could be a problem in the practice, and it is recommended to regulate this in the documentation, and working time should be very carefully regulated in the documentation. Otherwise, if it's not regulated at all, the working time will be determined by the employee at their discretion, and the employee may work any time he wants. So it could be really a problem for the employer. So it's highly recommended to regulate explicitly in the documentation the working time regime. Also, some issues connected to organizational technical capabilities, information exchange should be, let's say, clearly determined between the employer and employee to avoid any unpleasant issues in practice. And another issue to be considered is the fact that in some cases the employee would need to return to the office. It could be a request of the employer or the initiative of the employee. And this kind of return to the office is provided in the Russian legislation that it's possible. And it's not so, it's not regulated in details. So it is also recommended to regulate these issues in the documentation to ensure that everything is clear for both parties. Organization of work is also important for remote work because employees are working not in the office, and the issue with the equipment, with the required tools for work are really important. In some cases, employees use their own equipment or rented equipment, or they could be equipment of employer. And all these aspects should be carefully regulated in the documentation, and compensation for equipment, if it is equipment of the employee or rented equipment, should be explicitly provided. The term, amount, order for using the equipment, if it is the equipment of the employer. So all this is important to be regulated in the contract, in the documentation. The remote work raise a lot of issues connected to work discipline, because employees working remotely were beyond the control of the employer, and in some cases it was quite problematic, because there was difficult to monitor the work, to control the working time regime, the availability, the receipt of requests, responses, and the results of work. Also some kind of violation in confidentiality, for instance, when information was sent to some external email address occur in practice. So all this requires let's say to be reviewed, to be adjusted in the documentation, and this aspect should be taken into consideration when we are considering remote work. The issues with documents exchange are also quite essential for remote work, because the idea with electronic signature is still in place in the current regulation about remote work. It was in the past, and also it remains in the current legislation. However, there are some exemptions which we speak later. So general concept is that a specific qualified enhanced electronic signature should be used by the employer for employment contracts, for addendums to the contract, for termination agreements, and whereas the employee could use either qualified or non-qualified signature. Alternative for this could be only exchange of hard copies. So there are no other options in this respect. And what was introduced in the legislation is that in some cases, for the documentation, for the commission that is internal labor documentation, policies, orders, notices, requests, other HR documents, it is possible to use another kind of a signature, not necessarily one of these, qualified or non-qualified, or it can be even possible to provide in the internal documentation or in the employment contract the way how the documents could be signed. It could be just a delivery by way of email with a respective confirmation that the employee receives it. So it's a kind of issue that both parties could decide and could choose the preferable option. But it is important that everything should be stated explicitly in the documentation, and the due receipt should be somehow fixed, and employer and employee should have confirmation of this due receipt, just to avoid any unpleasant issues in practice when one of the parties can say that nothing was received. Another hot topic was during discussion of the law on distant remote deployment is the termination of remote employees. And current regulation so far, before the 1st of January 2021, still allows that termination grounds could be included, additional termination grounds could be included in the employment contract, which means that apart from those mentioned in the law, in the employment contract with remote employees, it is possible to have additional termination grounds. However, from 1st of January 2021, it will no longer be possible, It could not be any additional termination grounds in the contract. And we could say that basically it could be interpreted as a right measure, because in practice what we had in this period, that sometimes employers elaborated some really contradictory grounds for the employees, and there were a lot of court cases when employees were reinstated in job because the grounds were not clear, were not clearly stated, and it creates a lot of let's say violations of rights of the employees. But at the same time, we should say that Russian legislation, there is still some certain category of employees which is called home workers or home employees. Well, the difference between home employees and remote employees is that normally remote work is done by some kind of employees like translators, programmers, designers, who use the IT tools, some kind of internet or whatever, to perform the work and to send the results to the employer. While home workers home workers are the employees, for instance, packers, stewards, some technical, let's say, specialists who are not providing some intellectual result. And these employees could also work at home, but they are called home workers, not remote workers. And with these employees, it is still possible by the law to have in the employment contract any additional ground that is elaborated by both parties, that is signed in the agreement, that is determined and signed by both parties. And we could expect that there could be some interpretations, some attempts from the employers to transfer some employees from remote employment to home employment. And I think that probably there would be some interpretations from state authorities to avoid such, let's say, violation of legislation, because the difference between home workers and remote employees is quite clear. However, we cannot exclude that in practice there could be some kind of abuse in this aspect. And regarding the termination of remote employees, the Russian law defines explicitly some additional termination grounds. It is so-called absenteeism for remote employees, when the employee is not interacting with the employer within 2 consecutive working days following the date when the request from the employer was sent to the employee. And such kind of interaction is done without any reasonable excuse. And such kind of absence of interaction could lead to termination of the employee, which will be so-called disciplinary termination, with fulfillment of all the procedures required for this disciplinary violation, which is they need to receive written explanations, to prepare a lot of documentation, and let's say to terminate the employee. Also, another possibility is to terminate the employee when he changed their location, and in this case it is impossible to work under the same conditions. This option is only applicable for permanent remote work, so when this kind of work is for unlimited period of time. And one of the possible options when location of employee is changed are mentioned on the slides. It could be transferred to the region with so-called northern allowances. It could be change of time zone when it is not convenient for both sides to work, or transfer to the region when there is an absence of some technical capabilities, for instance, lack of internet or whatever. So that's basically all the main issues related to the new law on distant remote employment that should be taken into consideration. And due to some kind of new matters mentioned in the law, it is important to review all the documentation that the employers currently have for the employees who are working remotely in order to allow full compliance with the current legislation and to avoid any kind of disputes or complaints from the side of employees. So this is really something which is required to be done in the nearest future, as from the 1st of January the new law will come into force. Another really important and problematic issue in case of remote employment is the confidentiality, because due to lack of control from the side of employer, of course, such issues rise even more often, because the disclosure of information could be done by way of sending information to some external addresses, to cloud drives, to the messengers, to flashcards, and here important is to regulate all the issues connected to disclosure of information in the internal documentation, and it should be really carefully prepared, and all the possibilities for the disclosure should be expressly stated, so that employees could really understand that such kind of behavior could lead to some consequences which are not favorable for the employee. And confidentiality could be regulated not only in the internal documentation, but quite often in practice, there are such kind of so-called non-disclosure agreements which are signed between the employer and the employees. This is considered as a separate civil law agreement, which can regulate the issues with penalties and other civil law matters, which cannot be regulated in the employment relationships. Therefore, sometimes a separate civil law agreement could be better than just a clause in the employment contract about confidentiality. However, we should understand that even though an NDA can regulate the issues with penalties, with losses, and all the other issues that are allowed under the civil law, of course, there are also certain aspects to be considered even in this case, and we will describe it in the next slide. But employment law regulations are only limited to termination. So it means that if there is a disclosure of information, the only option under employment law is to terminate employee. Of course, it should be a documentary proof. It should be carefully provided in the documentation. All these matters should be considered, but the only consequence is the termination of the employment contract. But in some cases, the penalties, the losses are more important than just to terminate the employee. And in case of any kind of disputes, it is important in any case to confirm that all the due measures for protection of information were taken by the employer. Therefore, it is really very important to have all the documents in place and to regulate carefully all these issues. And a list of the measures are provided by the law and should be included in the documentation. But we should say that even with the non-disclosure agreement, which is a civil law agreement and allows to recover penalties and losses, in case of a dispute with the employee, it is really problematic to recover the penalties and losses, because in all cases we need to, first of all, to confirm that the disclosure, due to disclosure, there were damages, losses. So in other words, there should be a link between disclosure and damage. So damage, losses should be a result of the disclosure. And in practice, it is quite difficult to confirm this, this link. between two different let's say events, disclosure and damage losses. Another problematic issue is to justify the full amount of recovery. And in this case, sometimes in practice, when it is a, let's say, case when the client's database is stolen by the employee, only the real damage can be received by the employer. And by the real damage, sometimes the courts interpret just the cost of the data storage device where the client database was saved. So of course, it's not the same as the, it doesn't have the same value as the just a device and the database of the clients. And summarizing the above, we should say that even though a non-disclosure agreement could allow us to regulate the issue with penalties, with losses, and to it could be understandable that it guarantees us some kind of protection. In case of dispute, it could be problematic, and non-disclosure agreement normally is served more as just a preventive measure, and which of course does not mean that we don't need to draft this document, but we should understand that in case of dispute, certain problems could arise, and such kind of agreement could not guarantee us a full reimbursement of penalties and losses. So thank you for attention. If there are some questions, I'm ready to answer.
So thank you, Igor, for illustrating to us the various distinctions in terms of remote work and distant work in Russia, which is, and all the nuances which are connected to these distinctions. So I just would like to understand from you, last point, what kind of advice can you give to an employer who would like to protect the value of the information, of the confidential information, in terms of, let's say, employment agreement for one employee who discloses confidential information to the third parties, in terms of practical advice?
Well, it is recommended, let's say, to use all the possible options to protect the interests of the employees. I mean that to use the options that are provided by the employment legislation and also by civil legislation. Of course, it could be recommended to elaborate all the required documentation to protect the information, to describe what is considered as disclosure, to describe the access to this information, all the required issues under the legislation, and to have a separate civil law agreement could be also recommended. Of course, as the court practice is quite contradictory, it should be noted that the document should be very carefully elaborated, and the more detailed the documents, the better. And all the various possibilities should be taken into consideration in the documentation. Of course, it is not guaranteed 100% that we can receive a full reimbursement, because court practice is quite contradictory. But in the cases when employers elaborated the documentation in a careful manner, there was, let's say, there is more probability of reimbursement of expenses, rather than in case there is a lack of documentation or it is not so carefully elaborated.
And shall there be a proportion between, let's say, the loss of value and the penalty? I mean, penalty must be reasonable, or we can choose any amount we want?
Basically, it could be any amount, but of course, we should understand that we should focus on the examples from court practice, because the courts for sure will can decrease the amount which could interpreted by the courts as not so reasonable amount. And currently there are a lot of samples in the practice, a lot of examples, and we should let's say try to use some amount which is let's say provided by the courts, and consider the court practice, which is changing very fast, and let's say should be reviewed every time when we elaborate some documents.
Thanks, Igor. It looks like the legislation is, let's say, very rapidly adapting to the new situation, which is related to COVID-19 and the new, let's say, trends and patterns that are becoming familiar to us, like distant working. I have only one organization question, which concerns the slides. The slides will be distributed among the participants. Those who did not have the chance to participate but still registered, if they make a specific request, they also will receive our slides. In terms of other activities, our firm has drafted several articles and legal alerts on main of the points that have been touched today. So what we have seen today is just, let's say, a general framework, but we have also some more specific documentation, legal documentation on this topic, which is still available to those of you who are interested. So if you have a specific topic which have been treated today, you can specify your preference, and maybe we can send you also some other material which is interesting for you. Last point is that continuing this seminar, those of you who would like to have an interaction with our colleagues, with our professionals, are free to do it. There is let's say a free one-to-one session which is allowed to our clients, the clients of the law firm Berti, or the members of the Russian-Italian Chamber of Commerce, excluding other consultants, of course, just enterprises and companies. Those of you who would like to have, let's say, a private session one-to-one with us, it's in order to understand their problems and to see if there is any need of legal help. We are ready here to discuss and be available for you. So you can make a specific request at the addresses which were shown on the slides of Lisa Pestriakova and Igor Brazhevsky. You can even use my personal email address, which you can find on the internet, or the general, let's say, the general address of the firm, which is moscow@dejalex.com. So those of you who receive also this link, if you would like to go deeper into this discussion and have some clarification, we are ready to be here. So thank you to the speakers for their excellent work. Thank you to everyone. I will leave the floor to Leonora for the last final greetings to everyone and let's say final greeting. Thanks.
Thank you so much, Armando. It has been very, very interesting also for me to listen to the speeches of Igor Brazhevsky and Lisa Pestriakova. I thank you very much, all of them. And I think that it could be also interesting for our members, member companies. So I suggest you to deepen these subjects, these items presented today, maybe in some open discussion with our company members. So I thank you very much for inviting me for the introduction, and I hope to see all of you, and not only all of you, but other interested companies on the 24th of January and 4th of February. Thank you so much, and have a nice day.
Thank you from us, and goodbye to everyone.